Have a seat, everybody, please. All right, good afternoon. We're here on record in 3AN 1409599, Civil Alaska Dispatch versus Sean Parnell. How about if everybody identifies themselves, please?
Whitney
Miss-
Bachelor for the state.
Okay,
John McKay for the Plaintiffs Alaska Dispatch News and Alaska Public Media, Your Honor, and with me at the council table is Tony Hopfinger, editor of Alaska Dispatch News.
okay, and sir?
And Your Honor, Alan Birnbaum motion.
Okay. Well, good afternoon to everybody. This is on short notice at the request of Alaska Dispatch and the other news organizations. And we held a short hearing yesterday afternoon to sort of decide how procedurally today's hearing would go. And the state had, under the rules, the state has 24 hours to respond to the motion on expedited, and so that's why we're here today now at 1:30. It's time for oral argument. My understanding, let's see, we set up yesterday that we'd get notice by 11 if there were going to be any witnesses. No notice, so no witnesses, right, Ms. Backelor?
That's correct, Your Honor.
All right, then it's just oral argument, and if possible, I'll give you a decision at the conclusion. If not, I'll take it under advisement. And let's just divide the time. 20 minutes each sufficient? And I can watch the clock. Mr. McKay, you'd go first and last, so if you want to reserve time. With 20 minutes each, you'll then reserve a little time for me if I'm able to make my decision at the conclusion.
Thank you, Your Honor.
Okay? Do you want to reserve any time?
I would, Your Honor.
How much you want to use at the outset?
Well, I'm going to be trying to get through the last 10 pages of the response that I just got, probably while after I'm done talking the first time. So I'd say 10 minutes, Your Honor.
10 minutes. I'll watch the clock for you. I'll let you know a few minutes before that's up.
Thank you. And if in any time I don't use to begin with. May I have another 30 seconds to try?
Sure.
Thank you.
Yeah, we just got a response from the state, and I've read that 18-page response. Thank you for that. Let me know whenever you're ready.
I know that Your Honor is, may I sit at council table, Your Honor? First of all, I appreciate you hearing us on shortened time, Your Honor. Apparently the Attorney General's office emailed this to me as I was leaving to come down here, so I have not had a chance to read through it, but I have skimmed through it, and I think I can respond to most of what's here. If necessary, I'd ask that I be allowed to follow up, but I believe that I can see most of what's here. So I would just start by saying, Your Honor, that I don't think we need to go into great detail about why we're here, what the Alaska National Guard scandal, for lack of a better term, is, as we've defined it in the pleadings and the memorandum and the declaration, to have the meaning that, we're referring to a controversy I think at this point is quite well known. It's become an issue, a significant issue in the gubernatorial election campaign, but it's more than that. It's something that affects all of us in the state, all of us who are either have families or members of the Guard, who have children who went to school with, their classmates or themselves preyed upon by some of the people involved in this scandal, people who rely on and respect and support the Guard's duties or service to our community. So all of us are affected by this, and will be after this hearing today, after November 4th, as the facts about this controversy continue to come out in records that we assume will continue to be produced. Why we're here today is that this scandal has sort of two components. One is what I've just described, the underlying importance of looking into a controversy that has deeply affected our community. In fact, even this last week or so, the Anchorage School District has said that they won't allow National Guard recruiters in the schools. And this is being felt in many ways and is a deeply felt concern in our community. But it is also an election, it is an issue because the governor is commander-in-chief of the National Guard and is the chief executive of the office, which has conducted most of the communications about this, had the authority to oversee the National Guard, to hire, retain, or fire the people responsible, has the documents which the public is entitled to look at that would help understand this controversy. Governor Parnell asserts that he has acted reasonably in good faith at all times to respond to what he knew when he knew it. His critics say that he has acted insufficiently and should be held accountable for doing so. We don't take a position on which of those is correct, but we do take a position that the public is entitled to know what the documents about this show so that they can make up their own minds about who's correct in this particular aspect of their decision-making process. Now, the state says that in this filing that this is not an election issue and that there is nothing about this agreement that the parties entered into on October 9th to facilitate and get a prompt review, prompt disclosure of documents to accomplish just what I was talking about, getting information out to the public so that it could be fairly considered and each side would know whether there was support for their respective positions and the public could evaluate their competing claims. They say, well, this is not an election issue, this has nothing to do with that, this has nothing to do with the agreement. That makes no sense, Your Honor, that this agreement has nothing to do with that. Otherwise, why would the parties, in the context of a dispute or a request for public records, which has been, so the news organizations have been stonewalled on for weeks and months, and this is an ongoing dispute. More facts, I'm sure, will come out over the following months and possibly years. Why was there an urgency that led the state to agree to provide documents as soon as possible, not just as soon as practical or anything else? The agreement is that the Department of Law agreed to assign a team of attorneys to direct them to promptly cooperate fully with the plaintiffs, to process the search of documents in order to effectuate production of the releasable document records as soon as possible, and to produce a log of any responsive documents to be withheld as soon as possible. And we specifically met and specifically agreed, as the state points out, they're not required by normal public record suit to provide rolling production, but they did. And not only they did it, they suggested it. So to suggest that there is some reason why this is a normal situation, has nothing to do with trying to get information out to the public before the election, simply makes no sense at all. And I say this with all due respect to the Department of Law filing this memorandum on behalf of their client, I understand, but they have done yeoman work to honor the agreement that they made and that the Office of the Governor made. And we were told at every step that the Office of the Governor supported this. It's not like they went off in some rogue direction and entered into an agreement to actually follow the law and get documents that had been requested for a long time because the governor's office wasn't doing it. The governor's office, we are told, was on board and fully supported us entering into this agreement. But part of this agreement ended up when we announced, when we filed this suit, that we were going to promptly follow up the filing of the suit with the filing of a motion asking this court for relief on an expedited basis. The Attorney General said, can we proceed this way? We will get you documents as soon as possible. We will let you work with our attorneys to prioritize the searches. We will give it the highest priority. We will put other things on hold. We will give you rolling production. And when things come out, you can talk to our people and try and refine searches so you get things as closely associated with what you're looking for as quickly as possible. It makes no sense to say, oh, but that had nothing to do with the fact that we were all in some sort of, we were interested in doing this before the election. We weren't doing it for, Christmas or something. We're doing it because there's an election, because people are entitled to know this information before the election. So, and on October 9th, when we met at the Attorney General's office, one of the things that we agreed that we would immediately search, put together a search of the database that where electronically stored emails are for the state. But there were other documents that had been requested from computers of the various employees, from normal paper documents, copies of the attachments to the Inspector General's report, the Department of Defense National Guard Bureau Office of Complex Investigation report, a variety of these things that had nothing to do with, that didn't have to wait for the formulation of a request that would be processed by the computers, wait for the computers to run, waiting for the state to put that into Clearwell, all of which they did promptly and effectively, and we applaud them for that. But in the meantime, they also said those other requests that we had made were going to be cleared promptly while those other searches were going on, and that they would be forwarded promptly to the Office of the Governor, which we believe they were. We have no reason to believe that all the representations that we've been getting from the Attorney General's office virtually daily, but certainly many times during this last 3 weeks, have not been completely true, that they have been forwarding things to the Attorney General's office, including documents that that included, I see that there was a representation that on October 21st, which would be 9 days ago, that the Attorney General personally delivered to the Governor's office 717 pages of documents that were ready for executive review. And my belief is that there may have been documents provided before that as well, but I don't know. I'd have to go back and look at my notes more carefully. But in any event, the fact is, we see this 12,300 records returned. Obviously, a lot of those had to do with the National Guard going to, dealing with the Japanese earthquake or the Galena or polar bears, whatever. If you look through, a lot of them are non-responsive. And I think, as I said yesterday, I don't want to get hung up on the wrong number, because we're not asking the Governor's office today or you today to undertake some massive and impractical task of producing or going through 12,300 documents or any other thousands of documents. The relevant number to focus on is none, Your Honor, because that's the number of documents that they have produced out of this 12,300 email records, even though they said that those would be produced on a rolling basis, and we would either get the documents that were being sent over or a privilege log showing what documents were not provided. Because
let me ask you about the privilege log.
Yes.
Ms. Bacalar writes in her opposition of today that on October 24, what's that, 6 days ago, the state sent a 352-page log, and then 2 days ago, October 28, a 135-page log.
I'm not aware that we were sent the second log, Your Honor. I was aware that we were told there would be something coming. But, so I have not personally seen this, but either way, Your Honor, I have seen the first one. And we appreciate that, but it's not a privilege log. It doesn't tell us what was, it's something that they, I think, provided because they're embarrassed that there's nothing else coming over, and to help us.
Can you show me whatever it was? I don't need to see all 352 pages.
I got it as a something from a Dropbox that was downloaded on my computer. I don't know if the state can show you something tangible.
Bacalar, do you have a hard copy of anything?
We don't have hard copies, Your Honor. Both of those logs were delivered through the Dropbox.
Okay, here's my question for you, Mr. McKay, and Ms. Bacalar. I'll probably have the same question for you. The public records disclosure laws require, they give, by statute, our legislature has said that public records are supposed to be open unless specifically closed, or accepted, and the various agencies and branches can create their own regulations. And here the governor's office, administration, et cetera, has said, fine, we adopt these regulations that say, we'll give you a privilege log. We'll either give you the documents or a privilege log within 10 days. If we need another 10 days, we'll ask for that. I'm paraphrasing, of course. So it seems you either get the documents or you get a privilege log or a statement of how they're looking for it, but the person's out of town or something like that. The various exceptions
Right.
under the statute and regs. Nobody's showing me this log. I just saw reference to it by Ms. Backlar about a half hour ago.
Your Honor, I don't think anybody contends that that is a privilege log. States
Ms.
nodding.
Backlar shaking her head, no?
No, Your Honor, it's not.
That's how I read the memo. Is that wrong?
No, the logs are actually logs of the emails identified in order to assist
Okay.
plaintiffs to narrow down which ones they want us to prioritize.
And we appreciate that, and we have used it for that purpose. And as far as we know, the state is represented that has taken those suggestions and implemented them. So
Okay.
we appreciate
Second-
that.
Second question I have for you is kind of focusing on the 10-day issue under the regs about a privilege log. When was the first public records request made?
Well, Your Honor, you mentioned yesterday that you were interested in this timeline, obviously, is how we got here and why. And I would submit that this is a crisis to the extent that it is, or has been described that way, manufactured or created by the Office of the Governor, and for this reason. So I think I alluded to maybe an initial request being made by one of the parties, by Alaska Public Media, in particular Alexandra Gutierrez, in May. And let me come back to that in just a second. I think that Lisa Deemer from the Anchorage, at that time Anchorage Daily News and Alaska Dispatch News, made a request on June 17th, to which Randy Ruaro, the special counsel to the governor, who I believe is in charge of public records requests in some fashion, says to her on June 17th, "We will thank you for your request, Lisa. We will start processing the request and provide documents for a legal and privilege review by the Department of Law." To my knowledge, that not only didn't happen, it's directly, it just simply didn't happen. Although we, reasonably believed that it would happen, the Department of Law has informed us that they never got documents from the governor's office for a privilege review until after we filed suit. So we believe that that's false, in fact. Or not false in the sense that he said something false at the time, but he represented that something was going to happen that didn't. And relying on that, we assumed that that would take some reasonable time. In addition to that, Alaska Dispatch News reporter Jill Burke also made requests. I think the relevant time to look at in response to your question, Your Honor, is that the denial letters for these requests were given to the parties. They're dated July, in a letter dated, September 26th, delivered after the close of business on September 26th, so that, for example, Lisa Deemer got hers on, that was a Friday, after the close of business. Lisa Deemer got hers on Monday morning, the 29th. Within 7 business days of that time, we filed suit, Your Honor.
You're saying the state gave you denial letters?
Yes, Your Honor. They're referred to in the complaint, and that denial letter to both APRN and to Alaska Dispatch News was only finally given out on dated the 26th, but actually delivered after that date, after the close of business on that
Do you
date.
have a copy? It's
I-
not attached to the,
It isn't attached to the
Wednesday.
complaint, Your Honor. It's a
if you got a copy, I'd like to see it. Anybody? Ms. Backlar,
I
Mr.
don't have a
Birnbaum,
copy on
anybody?
hand, but we can get that to you, Your Honor.
and we might, if you're, might be able to
What
even
did-
transmit it
Par-
electronically to you if you like.
Well, tell me, what did the denial letter?
It was a lengthy letter asserting many privileges and basically denying everything, indicating that broad broad, aggressive assertion of privileges, essentially shutting the door on getting anything meaningful. Accompanying that was a 56-page packet, which was simply news clippings, some of them generated by the people who were making the requests themselves, basically a meaningless response, which I would not clutter the record up with because it has no bearing on anything. But it very clearly said that, it sent the message that we weren't going to be getting anything more. Then curiously, as we got ready to file, we got additional correspondence from Mr. Ferraro, and I think from Ms. Hull and Angela Hull in that office, indicating that they're still working on things. They might still produce things or would still produce things, but that's been weeks ago, and nothing still has been provided.
Okay. And I said I'd watch the clock for you, but I haven't been, I know I asked you a couple questions, but we've gone past it.
Thank you, Your Honor. If I could just say, Your Honor, and we'd be happy to get you a letter promptly if you want that, but I would just say that in terms of the response, in terms of that time, just to give you an example, from Ms. Gutierrez, who's here if you want to hear from her, but I'll just offer this. She submitted a response in May, but they said that they didn't get it even though it didn't bounce back, and even though she had told them it was coming over. They asked her in June to submit it again and started the clock running. She checked in regularly with them, was told each couple of weeks that it was coming, things were coming, it would be provided in August, and then in August went by, but she's been checking with them regularly. She said, look, are you going to just deny this? And they said, oh no, we're going to get your records. And then and that was shortly before they sent her a letter basically not getting the records. So I think if you have more questions, I'd be happy to answer them. I think the record is clear that on all fronts, they were essentially strung along. And I say this with respect, as I know that this is a job that is hard, and they've gotten some good cooperation at times from these people. But in fact, they produced no records, including Ms. Burke has asked repeatedly for, and we've asked through counsel, for even something as simple as the regulations require that the state keep a log of requests that have been made. Ms. Burke requested that so she could try and help the department, the Office of the Governor, avoid any unnecessary duplication of effort by contacting and seeing whether documents that were being produced for others could be coordinated. And they have not produced that, even though it's a simple records request, and counsel, I believe, has intervened, and we still have not gotten that.
Okay, thank you.
Thank you.
Ms. Baclar or Mr. Birnbaum? Ms. Baclar.
Good afternoon, Your Honor. My name is Libby Baclar, and on behalf of the Attorney General's office, I represent the Office of the Governor in this case. And that representation actually raises the first of two main points I want to hit on today, which is that the state isn't here to protect this particular governor or conceal information from the public. We're here to defend the office of the governor, regardless of who occupies that office. And that means protecting and asserting the privileges, including the executive and deliberative process privileges that the governor's office holds. So I'd first like to speak to some of those privileges and why they matter, and why this court should think twice about plaintiffs' invitation to skate lightly over them, particularly in a case of this nature. And then I'll address the implementation of the party's MOA, the Memorandum of Agreement, and the processing of the records here, why it's taken the time it has, and what the remedies realistically are at this point. But before I get to either of those points, I'd just like to touch upon a point Mr. McKay made at the outset as to what kind of case this is and what kind of case it isn't. It's a public records case. It's not an elections case. There's no election law cited in the complaint, and although plaintiffs argue otherwise—
The election is referred to in the complaint.
Correct. The election is referred to in the complaint.
The need for this, because of the election, is cited in the complaint.
Correct. But in terms of election law, we're talking about the implementation of the Public Records Act. The election is, Your Honor, a political backdrop to the legal issues under the Public Records Act. And that's a political argument, not a legal one. And therefore, it's not one that the court should necessarily entertain. And moreover, the election has been ongoing actually since October 20th, when early voting started, and that was 2 days before the parties entered into their MOA. So because it's a public records case, the court should be mindful of the fact, and I think as the court surely knows, not every public record is subject to immediate disclosure. Each record has to be reviewed confidentially and individually, both on the basis of federal and state statutes and various privileges. And that review is never a ministerial exercise, and never more than in a case like this. Mr. McKay mentioned the significance of the issues in dispute here. Or rather the issues involved in this records request. And the significance of these issues aren't disputed. Everyone agrees the records here involve highly sensitive matters of a hybrid state and federal agency, the Alaska National Guard, whose operations are subject to numerous provisions of state and federal law. There are serious allegations of sexual assault and other misconduct that have already been widely reported in the press. None of this is a secret to anyone here, I don't think. There's a complex federal statute, the Federal Privacy Act, that governs or partially governs many of the relevant documents. There are ethics complaints made confidential by the Executive Branch Ethics Act. There is personnel records potentially made confidential by the State Personnel Act. There are concerns about releasing the names of victims of sexual assault, regardless of whether they've been leaked or not leaked. This office has an independent obligation to protect those victims. The whistleblowers, whom we don't want to discourage from reporting malfeasance, there are open criminal investigations on alleged perpetrators of sexual assault and other misconduct whose individual rights to due process or whose prosecutions could be compromised with a single mistaken release of information. That bell cannot be unrung. And so figuring out where all of those laws are implicated in thousands and thousands upon thousands of lengthy email threads and doing so consistently takes time and a lot of time. And those are just the rights of third parties. That's before we even get to the
So let me ask you, how much time? The media says they asked in May, and that's how many months? 5 months, 6 months? How much time?
Your Honor, my understanding is that the two requests at issue in the complaint are a May 17th request and a June 28th request. And this, the court should understand as well, comes in the context of all of the other public records requests the governor's office gets. My understanding, and again, there's no evidence in the record here either way for what Mr. McKay just told you, but I'll tell you that my understanding is that the governor's office was working with the requesters, and the Public Records Act allows for that, and the regulations allow for that, working with the requesters to figure out, narrow the scope of request. I think initially the request was for all emails mentioning National Guard and CATGIS or something like that. There was a giant search done. It drew 50,000 documents, something of that nature. So it was a process that was ongoing since then. But it wasn't as though the governor's office was doing nothing during this time. My understanding is there was a back and forth and a dialogue with the requesters. But before we even, and that's before we even get into the content of the documents, because the
I need to ask again,
Yes.
how much time
how much time since the
to
request?
respond? How much time does the state need to respond to the public records request? The regulations promulgated by the Department of Administration say 10 days, and if they need more, then another 10 days.
And that's,
So how much time?
well, Your Honor,
I mean, these are the state's own regulations and statutes.
so the regulations say 10 days, and there can be an additional 10-day extension taken on notice, and then additional extensions can be taken from the Attorney General, but there's also a regulation that says that, you know, you can correspond with the requester, get information in writing as to narrowing the request, clarifying the request, figuring out a different deadline depending on the volume.
So I'm going to
Unfortunately-
ask again, how much time?
Well, it would depend on the number of documents drawn. See, I think, unfortunately, the Public Records Act and its implementing regulations are a little bit outdated with respect to where we are technologically. I don't think the Public Records Act was drafted and the regulations drafted long before, emails of huge volumes of emails could be drawn out of a public records request that could never be conceivably reviewed within 10 days. And the public records regs do contemplate working with requesters to do that. So how much time?
The regulations refer to electronic documents. The regulations were not written 50 years ago. They've been updated, and these are the state's own regulations, the Department of Administration's own regulations, the governor's own regulations. So my question, again, I have to ask, how much time the memorandum of agreement that the state entered into on October 22 said, okay, we'll do this on a rolling basis. My understanding is that representations by Mr. McKay is that not a single document has been provided and not a single log. And what the pleadings say, and your pleadings also say, the AG's office jumped right on this, put 10 people on it. You got 12,300 documents, but not a single document 10 people in 10 days can't, and going to the governor's office, they haven't been able to come up with even a single document or single log that
And-
should be released?
And Your Honor, maybe I can address that by getting to some of the privileges here. So the deliberative and executive process privileges that have been referenced in the motion papers, those are privileges that belong to the governor's office, whether, that office is occupied by Governor Parnell or Governor Walker or any other governor. They don't belong to the Department of Law or the attorneys there, and we can't waive those. The office of the governor is entitled to assert them, whether in this case or any other case. And again, doing that takes time. It takes individual review of the documents. And while validly asserted privileges can and maybe will ultimately be waived, the governor's office is entitled to review those documents and make that decision for itself. And it needs to do that amidst all of the other duties that the governor's office has to perform in running the state, which, needless to say, are substantial, including relevant to this matter, interviewing applicants for the adjutant general position that was vacated by General Kakis. There just isn't the authority for the court to realign the gubernatorial priorities, and for good reason, because as we say in the briefs, doing so runs the risk of a separation of powers problem, where the judiciary deprives the governor's office of an opportunity to review documents covered by the executive privilege, which brings me to the MOA between the parties, which I don't think plaintiffs are arguing is being violated, at least not by our department. But it's not, there's no deadline in statute for the client to take time to look at privilege issues. And it's not realistic to divorce the attorneys from their clients in a case like this, where there is that built-in opportunity for client review of attorney recommendations with respect to disclosures and withholdings. And the day after the lawsuit was filed, and plaintiffs readily acknowledged this, the parties began working to isolate and review responsive records. The searches plaintiffs requested yielded over 12,000 records. 865 billable hours of nearly a dozen attorneys were devoted to the task of separating the wheat from the chaff of those responsive documents.
But that's why I've asked the question, from all that effort, you've not come up with a single document
Well-
or a single log that the governor's office is then being able to review, even on the so-called rolling basis, a single document?
Well, again, that's actually not quite accurate, Your Honor. Those documents have been and are being given to the governor's office as the attorney recommendations are made, as the state software can process them, all pursuant to the memorandum of understanding. In fact, I think just before this hearing, a binder of documents was delivered to Mr. McKay. Nowhere is it contemplated that there's a specific time frame for the governor to review these privileges, and in fact, the MOA specifically contemplates that review. We cannot sever the governor's office from that process or some set number of records to be produced by a set day. This binder, I understand it from the Attorney General, this binder went to the governor's office. 717 pages of records given to the governor's office last Tuesday. Last Thursday, the Attorney General himself met with the Chief of Staff, Deputy Chief of Staff, to discuss them. On Friday, I understand he met with the governor to do the same. And these green sticky notes that you see here represent all the places that the governor's office has concerns and questions for the Department of Law to discuss with their attorneys.
But,
So it's-
Your Honor, I'm sorry to interrupt, and I normally wouldn't do this, but just so we're all on the same page, this binder sounds like, now it's being cross-referenced with this reference in the pleadings to 717 pages delivered a week ago. This binder was represented to us when it was given to us just as the hearing was beginning. It's one document. It's one set of documents that's the complete set of the OCI report.
Those are two different binders, Your
That's
Honor.
what I'm trying to clarify.
Yeah, that's a
because we
totally
have
different
nothing
binder.
else.
Right. So that's exactly my point. That's a different set of, that's a binder that's given on the OCI, the Office of Complex Investigations report. This binder here is all of the documents, 717 pages of documents reviewed by Department of Law attorneys that was gone through by the governor's, I understand, Deputy Chief of Staff, several of his upper-level staff, and these green sticky notes here are all the questions that they had for Department of Law on release of records. So it's not that an expedited process of documents isn't happening here. It is happening. But it's the expedition of that. It's not a requirement. It's a concession, not a legal requirement. It's a concession the parties made and reached in an attempt to get consensus in the litigation and move things along. And again, the timing of the governor's office, a review of these records, it's happening in good faith, but it's subject to other time constraints that are inherent in the commitments of that office. So, Your Honor, we would argue there's simply no emergency justifying expedited relief here, not a legal emergency anyway. The parties agree both sides are complying with the MOA, at least as to its execution. The fact that the governor's office is taking longer than plaintiffs would like to review our recommendations, the Department of Law's recommendations, doesn't necessarily create a justiciable controversy or emergency. There's nothing for the court to order here, at least not without disrupting and encroaching on the constitutional and common law privileges that no one disputes the office of the governor is entitled to assert. So for those reasons, the state would ask that the court deny plaintiff's motion. Thank you, Your Honor.
Okay. Thank you, Ms. Beckler. Mr. McKay, you get the last word.
Thank you, Honor. I guess I would start by saying, since it's been referred to, if I could just take a look since you've been talking about this. I don't know what you decided.
Well, let me make sure. Ms., hang on, before you open it, Ms. Baclar, is that okay or not?
This is just a demonstrative, Your Honor,
I just wanted to, I couldn't see from
Just
where,
hang on, everybody. Is it okay if he looks at it or not?
not opening it, I don't think.
and I'm not asking to, Your Honor, I just couldn't see what was being demonstrated from where I was sitting.
Okay.
So these,
I could see the top, which showed about 10 sticky notes.
so
I see that there's more.
there's a lot.
Thank you, Honor.
Go ahead.
So Your Honor, I don't believe that we're talking about, I understand that Ms. Bacalar has perhaps understandably tried to distance a bit the Department of Law from the Department of the Governor, saying not only does the Office of the Governor serve as their client, but also the implication is that the Department of Law has some separate institutional reason, apart from representing a particular client, to assert privileges that might be asserted. It's an interesting position to be in, but I think what we need to focus on is not some invented constitutional crisis or some attempt to portray this as if you were to grant any reasonable relief here, as being an invasion of the separation of powers. I think instead what we're talking about is simply enforcing and implementing an agreement that the Department of Law and the Governor entered into freely, not something where you'd be asked to impose some bizarre, unprecedented and unknown set of requirements on the Office of the Governor, but simply to effectuate an agreement that the defendant has made in this case. And they keep referring to it as a October 22nd agreement. In fact, of course, it simply memorialized in the agreements that were made on October 9th. But so we're simply asking you to implement what we had agreed to. And on page 4 and 5 of the memorandum, they talk about delivering 717 pages of documents that were ready for executive review. It apparently glosses over, omits to report to the court various other disclosures that have been made, or we've been told have been made on an ongoing basis before and after this, from the Department of Law to the Department of the Governor. It also says that they've been diligently reviewing documents requested by the plaintiff, but have not yet completed its substantive review. But the agreement that we have specifically, expressly calls for the production of documents before the review is completed on a rolling basis, specifically because we all recognized the importance of getting out what information could be obtained in advance of the election in this short time period that we have. So the fact that they haven't completed their review is really irrelevant in that sense, that their agreement is that they will produce things as they reviewed it. It is simply not credible to say that the governor's office could not have produced one, let alone, if they, Ms. Bacalar represented yesterday in the hearing that a team of 10 lawyers has been working night and day on this. It's inconceivable that they would put in that energy thinking that there's really no particular rush on this. It was just doing this because everybody thinks it's a good idea. But also it's somewhat of an insult to say that that work should go to waste, because when it goes into this black box that is the office of the governor, not a single document comes out the other side. And these are documents that for the most part have been created by and known to the key people in the office of the governor and have been the subject of requests for months. They should have provided these themselves. They should be well familiar with this. And by definition, we are only asking you in this hearing, Your Honor, to give us the documents, and we appreciate the fact that the Department of Law protects all of our interests and the institutional interests of the state. in asserting what privileges might be asserted on behalf of their various agency clients. We recognize that they have an institutional role to play, and we respect that. We're talking about documents that by definition have already gone through that process. They have been cleared. They have been reviewed. As
Well,
Mr.
Ms. Bacala's got a good point, though, and that's they're partially cleared. The AG doesn't have the final say. The office of the governor gets a say there, too.
I understand, but to the point that, to the extent that she's making a separate point, which she has, that their office has an institutional duty, regardless of who the governor is or anything, to do this. They've done that. So then we're really just talking about the holdup in the governor's office. And that holdup is to review documents which they have had, which they have known about for months, which they were required, as you point out, by regulation to turn over, either to turn over or to provide a privilege log of weeks and months ago before the suit was filed. And the suggestion that there are regulations that allow them to do other things may be correct, except they didn't. They violated those regulations. Any suggestion by Ms. Bacalar that yes, there is that 10-day rule, and then there's maybe another 20 days, but then there's also ways that they can respond after. They didn't do that. And so the fact that there may be regulations is irrelevant only because they violated them. So what we're talking about is documents which they have had opportunity to, and we believe, I mean, unless they simply did not even do any kind of good faith or diligent search over those months for these documents and had no idea what they were, they've been well familiar with what these are. So I think it's fair to require them to respond to the crisis situation, if they want to put it that way, that they have created by completing the process of either delivering the documents which have been pre-cleared, have been subjected to rigorous and probably overly cautious review by the Department of Law at this point, to given the governor's office the advice that there are privileges that could be applied. Now they're getting these documents back that they created, that they were supposed to have searched for, and you would hope in good faith did actually search for and look at before they denied access to them, rather than simply denying access without ever even looking at the documents. Okay. So they should be able to do this now. They should be able to give us at least some of the documents. We're only looking at the subset of documents that the Department of Law has cleared, has said, here's privileges that can be asserted if you choose to assert them. We have a right to either have those documents, and I say a right, aside from the fact that they've violated the public records law till now, we have it right under the agreement that we have to have those documents now. And I would ask that the court order that by the end of the day, some substantial amount of those documents be provided, or to the extent they're not going to be provided, a privilege log be provided that shows what's not being provided, as the agreement specifically says, as soon as possible. And we're already at 11 days after the, or more than that, anyway, 8 or 9 days, I guess, after the day that 717 pages of documents were provided to a party that said we will provide things on a rolling basis to get them out to you as soon as possible, both the documents and the privilege log. And then I would ask that anything that they can't get out by the end of today be supplemented by the end of tomorrow, and at least once more by Monday.
Okay. Thank you. I'm going to take just a few minutes, and I'll be back in about, well, I'll be back in a few minutes.
Your Honor, may I just clarify one thing for the record?
You sure may.
The difference between 4025-115 and 4025-110, my understanding is that the state security office searches are subject to one provision of 115. That's this for electronic services and products, and they run the state security office searches. And there's no deadlines under that statute or regulation for those searches.
You know, I'm not sure what the relevance of this is. I would just say that we have an agreement that says they will be produced as soon as possible, and I direct your attention to that.
Okay.
I think
Thank you.
You're welcome.
Oh, okay, thanks. I'll be back in just a few minutes.
Court resumes session with the Honorable Greg Miller presiding.
Have a seat, please. Back on record in 3AN 149599 Civil Alaska Dispatch News versus Governor Sean Parnell. Parties have given their arguments. Thank you. I appreciate it. And it's been very helpful. This is a time for my decision. The issue here is the application of state statutes and state regulations and whether the state has complied with those statutes and regulations regarding public records disclosures. I asked various questions of both parties regarding the timing of requests and the timing of responses to see if either or both sides had or had not complied with the statutes. And I'm applying the statutes. I'm applying the regulations. That's my job, and that's how I'm interpreting the issue before me here today and what I'm doing. The parties entered into a memorandum of agreement on October 22 in which within that document it expressly stated that if there's a dispute that emergency relief could be sought. And so the state now says there's no emergency. But I think everybody would be kidding themselves to suggest that the upcoming election isn't just around the corner and doesn't matter, that these National Guard records are just not in any way related to the election. The complaint alleged that they were needed for the election. The MOA was entered for that purpose to try to accomplish discovery prior to that time, and then the state and the plaintiffs entered into the written memorandum of agreement saying that they could seek emergency relief. Either party could. And so I am finding that this is properly before me on that basis. Let me go through just a few statutes and regulations that I'm interpreting, and I don't mean to be, won't take too long in doing this, but these statutes were, of course, passed by our Alaska legislature long ago. AS 40.25, .110, and .120 in essence say that all public records are open to inspection unless there's a specific exception that applies to not make the documents open, and certainly privileges are one of those. And nobody here is talking about waiving privileges or taking privileges away from the governor or anyone else. It's just the timing of the issues here, and whether the state's followed the process required by its own statutes and regulations. .120 lists the exceptions. Public records are defined in .220 of the statutes as any books, papers, writing, drafts, etc., regardless of the format, electronic format or anything else. Obviously, what we're talking about are public records. AS 40.25.123 says that the Department of Administration shall adopt regulations for the operation and implementation of public records disclosures by agencies within the executive branch, meaning the governor's office. And case law, the Greenwich case has said that the governor's office falls within that statute and thus those regulations. 40.25.125 says that a party who feels aggrieved by production can file an action in the Superior Court and seek an injunction. So it's properly here before this court now. This isn't a new set of statutes. The rule has been around since territorial days in 1900. Congress had passed this rule with almost exactly the same wording as is now in the statute, except it used the word territory instead of state. Alaska, of course, became a state in 1959, and in 1962, the Alaska legislature formally adopted the public records statute that I've cited already as a statute. And then most recently, in 1990, the legislature added comments, strengthened this matter, or strengthened its position, and it said, public access to government information is a fundamental right that operates to check and balance the actions of elected and appointed officials and to maintain citizen control of government. Those aren't my words, that's the Alaska legislature's words in 1990. Put another way, the legislature made it very clear that it interpreted the disclosure of documents broadly and the limitation of documents, limiting of documents, I should say, narrowly. Well, as I said before, it gave the Department of Administration the legal right to promulgate regulations to implement this. And the Department of Administration did that, and those regulations can be found at 2 AAC 96.110 and thereafter. Point 110 of that regulation says, quote, "The purpose of this chapter is ensure that requests for disclosure of public records and for electronic services and products are handled in a timely, reasonable, and responsive manner without infringing on the established rights, legal rights of a person." More or less, it needs to be timely, but without waiving privileges, which is both of the arguments that the parties have presented here today. 2 AAC 96.200 of those same regs says, "It is the policy of the executive branch of government," that's the governor's office, the executive branch of government, "to disclose public records and to provide copies of those records in an expeditious manner." It is the policy of the executive branch of government to limit the collection of personal information only to that data necessary for the efficient administration of a public agency. And then it goes on with various other regulations, 0.210, 0.220, imposing upon itself the requirement that the state agency or office provide a privilege log, etc. Respond within 10 days, can get an additional 10 days if it needs to, but it has to provide a privilege log and to, what we're calling a privilege log, and to produce all requested documents that are disclosable. And it says specifically at 0.230 that a public agency may not discriminate among requestors or classes of requestors, such as academic researchers, state and federal agencies, members of the public, news organizations, etc. The requirements for a privilege log can be found at 2 AAC 96.325, and it's very specific. I've already touched on the time limits of 10 days, and if you need more time, 10 more days, and then possible extensions beyond that, but not just open-ended exceptions, or extensions rather. But what has to be in the privilege log are very specific statements of the date of the document and the author of the document, the recipient of the document, and what has what the claim privilege is. It isn't permissible per the statutes or the regulations to just broadly pass a hand over all the documents and say that they are privileged. Again, it is no one's desire or request, and it's certainly not my order, that privileges be waived. But these statutes, these regulations, do not permit just not producing the documents and also not producing a log. The log is so parties can test whether a claim privilege has been properly made. That's the whole idea of the privilege log. The burden of proof per the state's argument, and it's a correct argument, they cited at page 11 of their brief that they filed today, that it is the party seeking, the state agency seeking the privilege to establish that privilege. If they do that, the burden then shifts to the requesting party, here it would be the news media, to demonstrate that the need for disclosure outweighs the interest in the confidentiality. The state has said generally that it needs to review these documents, and there might be as many as a dozen privileges. And the state might be right, that there might be one or more privileges that apply. And these are important interests. But the state can't just say, I can't give you a time when we'll get to it. I asked 5 times, how long? And they couldn't give me an answer. That's not what the statutes, that's not what the regulations say or permit. The state and the news media entered into the memorandum of understanding that said that the state would work, would try to produce these documents or a log on a rolling basis. And yet, despite 10 people, 10 days, in that written assertion, nothing at all has been produced. I appreciate, Ms. Bacalar, you're saying that the document that you referred to in your brief of 352 pages is not a log, that's not being deemed by anybody a privilege log. That helped clarify things for me, and I appreciate it. Similarly, it helped clarify my decision and how these statutes are applied. With Mr. McKay, you cited June 17, 2014 as a date when the first public records request was made. Talk about it as early as May, but certainly by that June date. Well, it is not reasonable to enter into a memorandum of understanding and say we'll produce what we can on a rolling basis, meaning we, the state, of course, know that we can't go through all 12,300 documents by any particular date, election or any other date, and then produce none. The urgency was known to both parties who entered into that agreement. So I'm going to grant the request of the plaintiffs, and I'm going to review the order again just to make sure that the wording of it is appropriate. I can tell you that I'll get that out within a half hour here today. I'll fax that. Fax or email? How would you like it, Counsel?
Email if possible.
Email and email to the state also. So I'm granting the motion, and I think that's everything. Anything else? Mr. McKay, Ms. Baclar,
May I
anything?
have one moment to confer with my colleagues, Your Honor?
Sure, absolutely, please.
Two quick things, Your Honor. First, the state's concerned about the third-party rights inherent in the documents, and we've been directed by our client to request a stay pending appeal. And procedurally, that's what we need to do before any order. Barring that, barring your granting stay pending appeal, we would ask for later than the close of business day, purely for technological reasons in the software that needs to generate the privilege log by its 10-20 minutes to 3. I don't think close of business today is going to generate that log,
What would work?
the document we order.
Give me a time that works for you.
I think it's
If you want to speak with
may I have one more
colleagues, go right
Thank
ahead,
you.
please.
Your Honor, if we're just talking about the 717 pages that we showed to the plaintiffs and to Your Honor, I think we could have that by a privilege log on that and production by close of business tomorrow.
Mr. McKay?
Well, Your Honor, I would hate to, this to be the first night that this round-the-clock effort stopped. I mean, I close of business tomorrow. I would think that we would be able to get some supplementary report by then, but I guess I understand if they can't go back and generate something the next hour, but they've indicated they've been working, well, literally round the clock, according to Ms. Baclar. I would ask that we get something by tomorrow morning. I appreciate that, and I also understand that, well, I guess that's our position. They've been working, they've been working on this already past the close of business. I would ask that this not be the day they stop doing that, and that in fairness, they be given until, say, mid-morning tomorrow to get the first batch of this privilege log out, and recognizing that they may supplement it later in the day by the close of business tomorrow. Tomorrow is Friday, so they get the rest of it out.
Ms. Baclar?
And Your Honor, again, I think, our position is close the business tomorrow. We were already up all night responding to substantive motion and preparing for this hearing. I don't know that another all-nighter in our office is realistic, but whatever the court orders, we will do our best to comply. We would request close of business Friday. And prior to that, a ruling on the stay motion on record.
Okay, and when I hesitated a moment ago and said I wanted to look at the proposed order, it was for that reason. I was trying to, the proposed order says close of business today, and I did not think that was appropriate, but I'm going to say noon tomorrow, so that's a little bit in the middle of what both parties are requesting. I'm going to deny the stay, and I've now looked over this order, and I'm signing it now, so I'll be able to give you a copy right now. All right, thank you. We're off record.
Thank you.
Your Honor.